Welcome to the Vicca Law podcast, Protecting Legacies, Resolving Conflicts. I'm Lidia Vicca, Director of Vicca Law, where we specialise in succession law, civil disputes and litigation in Queensland. If you want to safeguard your assets, navigate estate planning with confidence, or resolve legal conflicts effectively, you're in the right place. Join me each week as we break down complex legal issues into clear, practical insights, helping you protect your legacy and find solutions with certainty. Let's dive in. Interestingly, it is for the executor to prove that the will is the valid of will. So the burden is on the executor to prove that. And the way that you do that is really medical evidence, witness. You want contemporaneous notes when the will maker was making it. Quite often you'll see you'll get medical experts to assess capacity. And obviously sometimes they're doing retrospective assessments based on the medical records provided to them. And so you're effectively a trial. It's contested proceedings. And who pays for that? If the executor is maybe defending or pursuing the validity of a will in circumstances where they know it's not a valid will, or if they're behaving frivolously or vexatiously, a personal cost order can be made against the executor. Okay. Now, but at the same time, if the person is challenging the will and they really know that there's no basis to do it, if the medical evidence that they've already been provided is really indicating no issues around capacity, no issues around undue influence, that person can also have a personal cost order made against them. So it's risky and it really turns on the evidence. It's also very rare to have solemn form proceedings because of the cost. Easily $100,000 to $150,000. There's a lot of work involved. There's a lot of evidence that needs to be gathered. You need a barrister to assist you. It's a lot, okay? And it's not that common to happen, okay? So what usually happens is either, and it really depends on the facts, like everything turns to the facts of the case, but between filing a caveat and filing solemn form proceedings or shortly thereafter, there is usually some kind of mediation between the parties to try to resolve the issues. And the resolution of those issues is really some kind of different distribution that's in the will. Look, I've always said that if somebody has capacity to make a will and they're not being influenced and they come to me and they say what their wishes are, and even if those wishes are not the golden standard that I say, which is, equal distributions to everyone, I think that their will has the right to be upheld. That is my view. But I also understand the reality of society. Okay. I see people with lots of issues within their family. I see people that probably don't have capacity, that think that they do have capacity, trying to make these complex decisions. So I understand the reality of it. And it's a really hard area of law. But my number one view is, and particularly for people that have come to see me, if you have come to see a solicitor, you have received advice, you have capacity to understand that advice, and you have made a will, then that will should be upheld. That's just my view. Controversial, maybe. Probably not for people that are benefiting under that will, not controversial, but that's just the way it is. So if the will and I'll just finish up on the solemn form proceedings, if the court finds that the will is valid, then probate is granted and it's administered in accordance with that will. If the court finds that the will was not valid, the usual practice is it goes back to the previous will if there was one. It may go intestate. I can't think off the top of my head where they've done a redistribution, the court itself, because what you're just looking at is whether the will is valid or not. Earlier this year, I was involved in a matter whereby there were allegations as to capacity of the will maker. And what ended up happening in that case was a caveat was lodged, but it had lapsed. And we just held the view that it was lapsed because they didn't have any concerns. It was siblings. There was no further concerns. And we actually applied for probate and received probate in common form, the grant of probate. And then from there, the other side filed an application, I think it was Rule 641 of the UCPR, to say that requesting that the grant of probate be brought back in and that solemn form claim be commenced. And we were successful in defending that. So the application was dismissed and my client, which was the executor, did not have any adverse cost order against them. The costs were borne by the estate, but it was from the residue which those other beneficiaries were receiving anyway. So there was no impact on my clients as executors and beneficiaries under the will, and that was a great result. And what that really turned on was there was no medical evidence to dispute capacity. And what the court said, and there's a few cases, and I probably should have looked at them before I recorded this podcast, but basically, mere suspicion is not enough. You need to have something more than mere suspicion, okay, to have a common form grant revoked. And in that case, there was no evidence that was determinative in any way as to the capacity of the deceased person. Okay. There's no claim in the court. They didn't run an undue influence. They had kind of given us some correspondence maybe of some undue influence. But in reality, there was no question of capacity. And in that matter, and in a lot of matters I see where there are issues and uneven distributions between children, it's usually because there's one child that not takes over, but takes the bulk and the burden of caring for that elderly parent. And that's where the issues start to rise. That's where we get uneven distributions in wills. And that's where, we can kind of see these issues. There's these accusations of having undue influence. But I think the reality is that we all know, and I feel like I'm rambling, so I do apologize, but these are all my inner thoughts. But when you have someone that is caring for you, I think that as an elderly person, you do feel indebted to them in some way. I also think that it's very normal for an elderly person to think about their death and talk about their death with that person that is their full-time carer and probably their emotional and, mental support in a way. That doesn't mean that the person didn't understand their will. That doesn't mean they didn't have capacity. And I am quite passionate about this. And I was so happy for my clients in that case that we got such a successful outcome and that they were able to receive what they were entitled to under the will and kind of move on from this disastrous family situation. So if you have concerns about the validity of a will, please do contact me, www.vicalaw.com.au, or if you're an executor of a will. Next week, we're actually going to talk about what executors should do to defend a will and what you should do to try to keep the status quo of the will if you believe it is a valid will. So we're going to talk about that next week. But if you're an executor in that position where you think you're going to have to defend a will, and it's not a problem, I think, gathering evidence why someone is alive too. But if you're in that situation as well, you can hop on my website, www.vicalaw.com.au. I'd love to speak to you about that as well. So thank you so much for tuning in. I will speak to you next week where we're wrapping up our challenging of a will of a month. Okay, speak to you then. Bye. That's a wrap for this episode of the Vicca Law podcast, Protecting Legacies, Resolving Conflicts. I hope you found today's insights helpful in navigating your legal journey. If you're ready to take the next step in securing your legacy or finally dealing with your dispute, you can pop on my website, www.vicalaw.com.au, to book a free consultation with me, Lidia Vicca. You can also subscribe to our newsletter or find out more about today's topic. Your future begins now, and we're here to guide you every step of the way. Until next time, I'm Lidia Vicca, signing off. The Vicca podcast comprises general information and does not serve as a substitute for professional advice. Prior to making any legal decisions, individuals are advised to seek independent professional guidance and assess the suitability of this information for their own individual goals and objectives.